It is not okay in any way, shape, or form. No way, shape, or form. That is abuse. State of Wisconsin versus Christopher Stewart. Now, let's proceed to 23 CF 189 for sentencing. Mr. Schmidt, you may begin.
Sure. I'm going to be asking for some jail time on this. And the reason why has to do with his history. If you look at CCAP, Mr. Stewart looks like he doesn't have much history. When I look at it in Protect, though, I see there have been a lot of charges filed against Mr. Stewart over the year, and I wondered why none of those show up on CCAP. And the reason why is 2019, Mr. Stewart, domestic DC, did a DJOC there, completed it. That's why it's not in CCAP, got dismissed. Did a DPA on another domestic DC in 2017, completed that, got dismissed. Ordinance on a DC in 2014, another ordinance on a DC in 2014, ordinance on a domestic DC 2011, 2005, felony child abuse, DPA completed, dismissed. So there is a trend that goes back 20 years, at least to disorderly behavior, domestic related behavior. That's gone unabated. It also shows that when he's completed numerous DPAs and DGOCs, meaning he's done the conditions without getting in trouble on those. This would be the first one I believe he hasn't. For that reason, I think the court for this, the DGOC wound up being on the misdemeanor battery. I think the court should consider jail time between 3 and 6 months. I think 9 months would be too much because I don't know how much jail he's done in his life. It can't be a lot. I can't imagine he's done more than 10 days jail at a time. So ratcheting up to 9 months wouldn't make sense given his lack of actual criminal history. I'm hopeful that getting jail for the first time for this sort of conduct ever might deter his behavior better because he's been charged with it and gotten ordinance or DPAs and DJOCs constantly for this sort of behavior. Thank you.
Mr. Davis.
Thank you very much, Your Honor. So, Your Honor, while that may be true that he have had deferred cases in the past and successfully completed them, that resulted in no conviction. I'm going to be quite poignant on this. We were prepared to go to trial on this. And the issue, first of all, I'll say that this is a serious offense. I think it's a lazy argument to say it's a misdemeanor or it's a low-level felony. Let's just get that out of the way. This is a conviction. This does not bode well on his record. My client is employed full-time. And he will not get business if people start doing searches on him and seeing misdemeanor convictions. That doesn't help him. Or if he wants to switch and go to a company or a different company, this obviously isn't going to be a badge of honor. But this specific situation, so he was building a house. He has his daughter. It's a separated family. They're divorced. So there's the child, the ex, and he, and they have shared placement time. And she comes over, and every time she's at that teenage age where she'd have chores, she wouldn't do them. She wouldn't do her homework. She wouldn't help with the chores. She wanted a new house, and he did everything to build this new house on what I call a creek, not a river, but a beautiful home that he wanted to build for he and his daughter. And they were working. And he kept telling her, will you start helping? Will you start helping clean up the lumber? And he did take a piece of lumber, Your Honor, and he did not intentionally throw it at her, but he threw it in her direction and the board hit her. And he was a frustrated parent. He wasn't trying to hit her or smack her or take a board and hit anybody. He's like, come on, you just help, start working, start helping with the chores, help me around here. Not just don't come over and sit on your phone or your iPad or whatever it is. In any event, he understood that that's not how to handle that situation. He entered into the deferred judgment of conviction, and he did have some requirements to do an anger management assessment and follow through, which he did do, Your Honor. What's really tough right now is that he hasn't had much contact with her. He's not an alcoholic. He's not a drug user. He's a hardworking man, pays his taxes, and supports anything he can with regard to his daughter's success. Now, again, this situation, had it been handled differently, maybe he pulled his daughter aside, but I think where his head's at, I really want the court to know this, his head was not to be mean to her, not to hurt her, but he wants her to be successful and have some structure. Bad parent because of that. In any event, Your Honor, I'm asking the court to consider probation. Thank you very much.
Mr. Stewart, I am now going to turn this over to you
You don't have to, but if you want to tell the judge anything now, this is your right.
I don't know what's going on.
All right. I don't know if your father was angry and your father threw things when he was angry, but it's not okay. It is not okay in any way, shape, or form. No way, shape, or form. That is abuse. Even if you had zero intent to hit your daughter, that is abuse. It causes emotional trauma within your child to see you act like an idiot, like a jerk, like even more words that I cannot even say on the record. You were an awful parent that day. And if I read from the criminal complaint of what happened that day and how it went down, the officer responded to the address and made contact with Ben Stewart in the front seat of a pickup with juvenile 1 sitting on the passenger side of the truck. Ben told me he was taking juvenile 1 to get checked out at Burnett Medical Center. I had juvenile victim 1 get out of the truck and talk to her. Juvenile victim 1 was crying. She told me that her dad, Chris, had told her to use the tape measure when they were working in the yard. Juvenile victim 1 had gotten dirt in the tape measure, and Chris had told her that if she did that, she would not be going deer hunting. Juvenile victim 1 then was upset and told Chris that she was going deer hunting with her uncle, Ben Stewart, and he would be taking her. Chris then threw a board at her, which hit her in her arm. Juvenile victim 1 showed me her forearm, and I could see a mark on her arm where the board had hit her, and a bruise was starting to form. And then it goes on and says that he threw the board during the argument, but didn't mean to hit juvenile 1. That's what you told the deputy. He thought she would, quote, get out of the way, quote. You thought she would, quote, get out of the way, quote, when you threw a board at her. You hoped you thought she would get out of the way. When you were mad that she got dirt in a tape measure, and now you said, nope, sorry, I'm taking away your pleasure of going deer hunting, which is great to teach a young lady, by the way. And you said, nope, I'm taking away your fun. You're no longer going deer hunting because you got dirt in my tape measure, because I love my tools, because that's what I do. And so I got mad. No, you're not going deer hunting. And then she said, no, Dad. In parentheses, I may not be going deer hunting with you, Dad. I'm going deer hunting with my uncle. And I'm going to presume uncle's your brother, Ben, because Ben at that time, I'm guessing, was siding with juvenile 1, because how it laid down here is you thought she would get out of the way. You don't get angry over things like dirt in a tape measure. It's not like she was not picking up the lumber. It's not like she wasn't doing her homework. It's not like she wasn't cleaning up her room. She got dirt in the tape measure. And you got upset when she wasn't listening because you were trying to take something of pleasure away from her. And she said, no, Dad, too bad. So you threw a board at her. And your excuse was, I thought she'd get out of the way. But she didn't. Because you know what? A man throwing a board, a heavy, I'm going to guess 2x4, goes fast. It's kind of hard for, I think, a 15-year-old, if I'm recalling correctly, to get out of the way. That's rage. That's not a good parent at all. That causes trauma that she will have to live with, and she will have to try and figure out throughout her entire life how to resolve with or without having you in her life. Trying to build boundaries with having you as her father, because she doesn't get to choose. She didn't get to have that choice of, God, let me see, who do I want to have my father? Should I be born to, someone famous or Christopher Stewart? I'll choose Christopher Stewart. She didn't get that choice. And I'm not sure if you even truly comprehend and understand your actions that day. Because I'm going to tell you, that's not the first time that has ever happened. I'm guaranteeing you that. I'm guaranteeing that is not the first time you've reacted that way. I'm guaranteeing you that. You know that. You're acting like you're confused, like that was the first time you've ever acted that way.
First time I guess I've thrown anything.
I don't believe that. I highly don't believe that. If your anger and your boiling of emotion and frustration got to that level where you're, as Mr. Davis said, your head wasn't right that day, but your head was so explosive that day over dirt in a tape measure. And your daughter saying, no, Dad, Ben's going to take me hunting.
I've always taken her hunting too, but
Correct, but that's not the issue. The issue is not who's taking your daughter hunting that day. The issue is you exploded because she got dirt in your tool. You didn't like that. You tried to take something away from her and she stood up to you. She took control. You did not like that. You reacted, you took what you had, the board in your hand, you took that, you used that as a weapon, you gained control by taking that board and throwing it at your daughter, I guess thinking, I thought you'd get out of the way.
I've threatened to take the cell phone away, but that doesn't work either, so.
Oh, so what, did you try to throw a chair at her that time? Okay,
No,
so
she just, I take it away and say you're gonna do dishes. That was another time. She just goes next door to her aunt's house, calls her mom. Then I'm an asshole for taking the phone away. Sorry about my language, but then so I can't win at any of this. I've tried. I don't know how to shut the phone off. I pay for it, but I don't know anything about them.
But that's not the issue. And here's the thing, what you're trying to do. You're trying to control this situation right now. You're trying to divert this situation of what happened this day, your conduct, your behavior, to throw it back to the other times you weren't able to parent. I don't know. And that doesn't matter here nor there. Here nor there. Today is why you threw a board at your daughter. Why you let your emotions and your anger explode to throw a physical object, a weapon at your daughter. Now, do I believe that this does deserve a punishment? Yes, I do. But I do believe that there are other matters in the 24CF case that we need to figure out first, because those are very serious as well. There's a whole lot of things other than anger management and parenting classes and stuff. Those are great. Those are grand. Those are wonderful. Those are not enough. Those are not enough for me to determine whether or not you go and have a full psychological evaluation, because that's what my focus is on right now. I could punish you here today and I could send you to jail for 9 months here today. That's not going to accomplish anything but punishment. And that's not going to do anything in the meantime right now while I'm giving Mr. Schmidt and Mr. Davis time to figure out what's happening in the 24 case. So, Mr. Davis, you win. I agree with your argument. Well, not your argument necessarily, but your recommendation. So, at least at this juncture, and at least at this point with this case, I will place you on probation for 1 year. Imposed and stayed jail, 9 months. Consecutive to any other sentence.
What that means.
Any other sentence that you may now have or may have in the future.
Your Honor, can you explain to my client what that imposed and stayed means? I don't think
Yes.
he fully got it when I explained it to him.
All right. So an imposed and stayed jail sentence means I will place you on probation. That means you will be on probation for a period of 1 year. with certain conditions that I will lay out for you, bit by bit, word for word, so you can understand them. If you fail to accomplish my conditions, you violate probation, you will be revoked. If you are revoked, you don't come back in front of me for sentencing. You will immediately blip, go to jail and sit 9 months of jail. Okay? So it means you must follow what I'm telling you to the letter, to the T. Do everything that I'm telling you must do. All right? Okay? Is that a yes? You understand?
Yeah, yes.
Okay. The court is going to order $1,000 fines, fees, DNA surcharges, all wrapped up in one little blow. That will be paid, that will be due within 30 days. Conditions of probation. One is to have a full spectrum, complete mental health, psych evaluation, absolute sobriety, no alcohol, no illegal drugs. I am ordering an abuser intervention program treatment. That is a program that's designated to rehabilitate those who repeatedly use violence towards intimate partners or family. There is a history here of at least charges as it relates to domestic abuse or domestic abuse enhancers, and they've been reduced to either ordinances and or deferred prosecution agreements or deferred judgment of conviction. Therefore, you must do an abuser intervention program that is designed to rehabilitate or focus on individuals that repeatedly use violence and other actions towards intimate partners and or family members. Gainful employment, we don't have to worry about that. And I don't know what's going on with your child support, but make your child support payments. All right, what am I missing, Mr. Schmidt?
Nothing from me.
Thank you, Your Honor. Nothing further from the defense.
All right, then we are adjourned. Thank you.